My name is Emmanuel Perez, and I'm an attorney in Florida. I'm licensed in Florida since 1986.
Okay. And so what's your understanding of diversion programs or what you refer to as boot camps?
Okay. Generally speaking, there are a number of diversion programs. Some of them are catered for adults, and others are catered for youthful offenders. And I'll give you some examples. There is a program called the Pretrial Diversion Program, which is both for adults as well as juveniles, and they generally make it available for first-time offenders with minor infractions, such as possession of marijuana, drinking in public, disorderly conduct, shoplifting, and minor infractions like that. If you are an adult over the age of 18 and it is your first time in the system, 99% of the time, the prosecutor will offer what is called the pretrial diversion program. Depending on the type of offense that you committed, they will send you either to, for example, an anger management course if you got charged with some type of an aggravated battery and you had a fight in school. If you stole something from, say a store, Macy's, they'll send you to a values course. And they also have diversion programs for first-time offenders that commit domestic violence. If you are a first-time offender and you commit a domestic violence on a partner, on a domestic partner, they will offer you a 42-week course. And if you successfully complete it, at the end, they will dismiss the charges or otherwise place you on some sort of a probation, but you will be able, at the conclusion of the process, you will be able to seal your record and you will not have a felony conviction. There is also a diversion program for first-time offenders in the DUI program. If you are arrested for driving under the influence of drugs or alcohol, and there is no accident involved and no injuries, they will put you on a program called Back on Track. If you complete that program and successfully pay the fines and participate in the program, they will allow you at the conclusion to plead guilty to a reckless driving and not the DUI, which is a lesser offense. Those programs are generally available on a first-time basis only. In other words, only for your first offense. Now, what is referred to as boot camp arises out of, and if you want to look at the statute, you can type it in and it'll detail. Boot camp arises out of Florida statute 958.04. And it is generally for youthful offenders between the age of 18 and 21. In other words, you cannot be over the age of 21 if you want to participate in these programs. But these are for people or for offenders that have serious offenses. Generally speaking, like, a string of burglaries or a fight that results in some sort of an injury. Or a gang participation, those type of things. For instance, I had clients that had, at the age of 18 and 3 weeks, a string of neighborhood burglaries, about 7 or 8 of them. And what happens is that the juvenile court determined that because of their age and the amount of burglaries that were involved, that they were going to be prosecuted as adults. So they were transferred to adult court. But once you get there, you're entitled to the youthful offender program, which is otherwise known as the boot camp. That is generally a sleep away. You're not going to be able to, go home at the end of the course. It's usually a sleep away. But if you successfully complete that, certain offenses, not all of them, can be sealed at some point in the future from your permanent record so that it doesn't ruin the rest of your life. Those are examples of different diversion programs that are available both for adults and for youthful offenders. Each county has their own facility for this Florida statute 95804. Some of the facilities in some of the counties are nice and others are not so nice, depending on the budget that they've allocated for the youthful offender program. So for instance, in Miami or Broward, you're going to have a lot of money allocated toward that because of the population. So you usually have nicer facilities. You have more instructors or counselors, as opposed to the youthful offender program in Alachua County or something like that, that is often a rural setting that doesn't have the same type of budget that you would ordinarily have in some of the larger counties. The diversion programs are designed basically to give you one final opportunity before the record becomes a permanent record that will last until the day you die. Some of these programs involve, for example, you've seen on television where they take the youthful offenders to a state court prison so that they can see how terrible it is and where they may end up if they, if they stay on this track. So those are good programs, provided that the people that are monitoring them do good work. Unfortunately, sometimes, particularly with the boot camp and the youthful offenders, you have juveniles that have been committing offenses since they're 12 or 13 years old and happen to commit this last offense at the age of 16 or 17, and then they put them into the adult system and they are eligible for the boot camp, but you have what is essentially close to a hardened criminal who will only get progressively worse once he gets in a group setting with other juvenile delinquents. At the end of the day, it's really a matter of not so much the supervision they get from these programs, but how much his guardian or his parents are willing to put into the rehabilitation themselves. Because, the programs have an expectation that the parents will do something to, to help the youth out. Sort of like, your kid goes to school, but you got to help them with the homework. So a lot of that is determined by, what the parents put into the program. Okay.
Okay. And can you take us step by step and explain the legal procedure for juvenile offenders wanting to
Sure.
partake in diversion programs?
Sure. And let me tell you, the other one that I forgot, which is also a diversion program, is the drug court program. So for instance, if you were arrested as an adult with, say, heroin on you, you would get immediately booked and processed, and your lawyer would show up. And this is not for juveniles, this is for an adult, but your lawyer would show up at the arraignment and ask for you to be placed into the drug program. What happens is that within the next 5 days, you have to have a drug test to see if you come back, clean or dirty. And then you have to participate in the program and the counseling associated with the program for 1 year. You have to show up in court sometimes twice a month. They test you twice a month. And if at the completion of that 1 year, you have tested negative for drugs, you will quote unquote graduate from the program. That will come back to the judge that originally had it, who will be told by way of certification that you've completed the program, and then he or she will dismiss the charges against you and tell you, listen, don't come back, because if you come back the next time, you're not going to go in the program and you're going to get processed just the same as anyone else. The youthful offenders operate this way. If you are, say, someone under the age of 18 that is caught in burglaries, oftentimes youths are arrested for selling drugs on the street because street dealers prefer to use minors than people over the age of 18. And it's a way for you to work your way up through the drug trade so that you start as a street dealer. So generally, the kids that you see on the street either selling the drug on the street corner or hiding it are minors that are controlled by adults that are actually the drug owners. So for that kind of a defendant, he would get arrested for, say, selling cocaine to an undercover police officer who was posing as someone that was purchasing the cocaine. He would immediately get booked into juvenile court. The juvenile court evaluator would say, hey, this kid has gotten arrested 30 times since he's age 12. And that would go to another section of the juvenile court system where they would evaluate if that kid would be processed as an adult. If that decision is made, and his attorney would have an opportunity to go to juvenile court and try and convince the person that makes this determination not to put him into the adult system because, he's not going to do it again, or he made a big mistake. If the lawyer is successful in doing that, then it'll stay within the juvenile system. And when the kid turns 18, that record will be sealed completely. If he is not kept in the juvenile system, he will then be sent to the adult system. He will be processed there. And then the lawyer that represents the kid will come in and request from the court that he be placed in what's called Florida's Youthful Offender Program, which is that Florida statute 958.04. And then depending on the crime that he is charged with, he would get, counseling that's tailored for his particular issue. So as I mentioned before, if it was a crazy fight at school or something, he might be channeled into an anger management program. If it was a string of burglaries, he'll get a values program. If it's drugs that he's selling or using, he'll get put into a drug program. And at the conclusion of that program, they would certify that he's completed it, and the charges would either be dropped completely, or he would get what is called a withhold of adjudication, which means that he would not have a permanent record as a convicted felon. Generally speaking, those records cannot be discovered or found because they're in a sealed fashion by employers or schools or what have you. And unless you are applying for a law enforcement position or a position that is sensitive with the government or something, they are not likely to find that record, and they would need a court order to reopen it. It also happens that sometimes some of those juveniles are non-residents or illegals, and that could create a problem for that child with immigration, even if the parents are the ones that are applying. What the extent of the problem he may have in immigration, I don't know. I think you may have to ask your parents about that. But I know that juveniles often have issues because they've committed a string of offenses while the parents and themselves are not legal permanent residents.
Okay. And so, do you know if offenders need legal counsel to be admitted into these programs?
Okay, the usually you're entitled to a public defender. Um, and if the but here's the catch, at least in Florida. Um, if the prosecutor uh affirms to the judge when you are first arrested that whatever happens at the end of the day, they will not, and these are the key words, they will not be seeking jail. The judge has no obligation, and the law does not obligate him to assign a public defender to you. A public defender is assigned to you only when you are looking at the possibility of jail. So, in a way, when the case first starts, you get a little relief because one of the things with any criminal case is the uncertainty of what may happen to me at the conclusion of this, which is, oh, I'm scared I may go to jail. But sometimes you show up at the first hearing and you say, well, I'd like a public defender. And then the judge will turn to the prosecutor and say, will you be seeking jail? And if the prosecutor says no, that's a tremendous relief for you as the accused, because you know you're not going to end up in jail no matter what, but you don't get a public defender. And then you have to either defend yourself or you have to get a private lawyer, because the judge has the satisfaction of knowing that regardless of what happens, the state has said that you will not be getting jail. In order to qualify for a public defender, the state has to at least announce that they may seek jail, which they often do, so that they can scare the dickens out of you. And they really don't have to pay for the public defender. So if it's a bluff, if you will, you'll get, and you qualify in terms of, I don't have money, I don't have bank accounts, I have a job that makes $500 a week, but I don't have any savings and I don't have a car I can sell. The judge will appoint a public defender to represent you from the beginning to the end. Judges prefer to appoint public defenders to you because they don't have to deal with explaining it to the accused and having to deal with, issues that the person is not familiar with. So generally you will get a public defender, both in juvenile court as well as in adult court.
Okay. So what are the legal constraints or statutory criteria that govern the decision-making process by which youth are provided or denied access to these diversion programs?
Okay. Yeah, that is, it depends on the program. But the Florida statute 95804 actually lays out what the criteria is in black and white. For instance, the defendant has to be at least 18 years old or is a younger person that was transferred to the circuit court from the juvenile system. The defendant also has to be under 21 years of age at the time they are being sentenced, and they have to have been found guilty after trial or offered the court to plead guilty or no contest to a crime that is considered a felony under federal law. And last and most importantly is the defendant has not been previously classified as a youthful offender in the past. So that's the criteria for 95804. For the other diversion programs, it has to be the first time that you've entered the program. It does not apply to certain offenses. For example, child pornography, murder, aggravated assault, bank robbery. There are certain offenses that are just not even within the criteria that you can qualify for. Oftentimes, what does happen is that you may get charged with an offense that does not qualify under the criteria of pretrial diversion. For example, let's say that you have a lewd and lascivious molestation of a child under the age of 16. which is generally, a sick old guy that flashes or touches a boy or a girl that's under the age of 16, that kind of charge, you cannot go through a diversion program because they don't want a second opportunity for a person that pleads guilty to that offense because it's so horrific. They don't want that kind of person to get a second opportunity. But a lot of times, as you start the case and you start taking depositions and you get discovery, if you're lucky and you have the right case and you convince the prosecutor that the person is overcharged, then the prosecutor can amend the charge to something like a straight felony or a battery, and then that would qualify. So there are times that you are initially charged with an offense that does not qualify for a diversion program, and you can, after you convince the prosecutor, amend it in order for the person to plea out to an offense that will qualify and will keep that record sealed at some point in the future. And I would encourage you just to look at that Florida statute 95804, and it has all the criteria there, including any violations of probation or community control that they may impose on you, and if you violate those, and what could happen to you.
Okay. And I have a few more questions. Research suggests that quote unquote advancements in the juvenile judicial justice system, such as diversion, have proven less likely to benefit Black, Asian, and minority and ethnic children, as well as young people. Given your expertise, do you agree with this statement?
Given my experience, and we're in Miami-Dade County, and it's where I mainly practice. So in Miami-Dade, there is a proportionately lower number of whites or Anglos, if you will, than say Tampa or Orlando. So what I see both in the juvenile system and in the state system is that you have a disproportionately higher number of minorities, particularly Hispanics and Blacks in the system. I don't see too many Asians. But I don't want to say Blacks in such a broad context, because you often see, for instance, a very low criminal rate amongst Haitian Americans as opposed to Afro-Americans. Or you see a low crime rate amongst Jamaican Americans or Black from the West Indies than you do compared to Afro-Americans. So rather than to divide it racially, maybe culturally might be different, because you could have Black people or Hispanic people, and depending on where they come from and what their culture is in their particular country, you might have a very low criminal rate amongst a particular class of people that might be Black or might be Hispanic. So I don't like to characterize it with such broad strokes, but rather to look at the culture that gave rise to the criminality.